Saregama India, a well-known music company, once sued an individual, Sanjay Bansal, for selling a copyrighted music and recording without their permission. The court verdict was under the favor of Saregama, and the court asked Sanjay Bansal to stop selling the copyrighted recordings as well as the music without Saregama's permission, as well as asked him to pay the damages. This case illustrates the need to understand the copyright law and avoid unintended infringement, and even if you didn't mean to. Copyright infringement can deprive creators of their income and make it difficult for them to continue creating new content. Hi, my name is Nitya from Solve-It. As you have a little understanding of the copyright law, let's debunk few copyright myths with me. Myth 1. Idea copyright is misconception. Fact. Copyright only protects the expression of an idea, not the idea itself. This means that you cannot copyright an idea for a book, movie, or song. But you can copyright the specific way in which you express that idea. Myth 2. If it's on internet, it's free to use. Fact. Just because something is on internet doesn't mean that it's free to use. Copyright applies to all original works for authorship, regardless of whether they are published online or offline. If you want to use a copyright material, you should always take a permission from the copyright holder. Myth 3. Owning a physical copy of the work doesn't mean you are the copyright holder. Fact. Copyright ownership is separate from physical ownership. Just because you own a physical copy of a book, movie, or song doesn't mean that you own the copyright. The copyright holder has the exclusive right to reproduce, distribute, display, and perform the work, as well as to create derivative works. Myth 4. Being in a photo doesn't make you a copyright holder. Fact. The person or company that took the photo owns the copyright, not the people in the photo. Myth 5. Screenshots doesn't entitle copyright ownership of images. Fact. Taking a screenshot of copyrighted image doesn't give you the copyright ownership of the image. The copyright holder still owns the rights. Myth 6. Others have used the image, so I can too. Fact. Just because others have used the copyrighted image without permission doesn't mean that you can do the same. Each infringement is separate, and you are still responsible for obtaining permission from the copyright holder. Myth 7. If someone sent me photo, I am not responsible. Fact. Receiving a copyrighted image from someone does not absolve you of a copyright infringement. It is still your responsibility to obtain permission from the copyright holder. Myth 8. If I'm not making money, it's not copyright infringement. Fact. Copyright infringement can occur even if you're not making money from the copyrighted work. Myth 9. No watermark, so I can use a photo. Fact. Watermarks are not required for copyright protection. Copyright exists automatically when the work is created, regardless of whether it has a watermark. Myth 10. Published photos are fair game. Fact. Published a copyrighted photo in a newspaper or a magazine does not waive copyright. The copyright holder still owns the rights. Here is the bonus one. Myth 11. I don't know I was infringing. It doesn't matter. Fact. Ignorance of the law is not a defense to the copyright infringement. It's your responsibility to stay informed about the copyright law and obtain permission from the copyright holder before using a copyrighted material. By busting these myths, we hope to empower you to make an informed decision and respect the right to the creators. In case you have any doubts relevant to copyright or IP, get in touch with our IP experts at Solve-It. They would be happy to help you.